number 48, the people of the state of New York versus Everett b. McMillan. Counsel?
May it please the court, Alex Don of Appellate Advocates for Appellant Everett McMillan. I'd like, with the court's permission, to reserve 3 minutes for rebuttal time.
You may, sir.
Thank you. The parole search in this case was unlawful because it was conducted entirely by a New York City police detective rather than appellant's own parole officer. Therefore,
So he's part of this task force.
yes.
Does that not give him the same authority and rights to enforce the policies and the rules of the parole department?
It does not, Your Honor.
Why is that?
For the reasons that this court explained very clearly in People versus Huntley, which is good law, the parole warrant officer who arrested appellant in this case was not his own parole officer, was not acting as his own parole officer, was not standing in for his own parole officer. The person who arrested him, conducted the search, had one job and one job only, and that was to investigate and apprehend parole absconders. And
you agree that as a parolee, he had a reduced expectation of privacy, correct?
Absolutely.
So under Huntley, the combination of his parolee status and the information that the police officer had regarding, the tip about the gun in the car, put that together, why wouldn't that suffice, even if it wasn't enough just that he was a parolee?
Because, as this court explained in Huntley, we don't just put things together like that in this context. Because
Well, but Huntley says if there was probable cause, the police officer, of course, could do it. So
absolutely,
and doesn't this get pretty close to probable cause?
It certainly doesn't establish probable cause. Probable cause wasn't preserved. Probable cause was waived. The people told the court before the hearing, the only reason we're here is because of the parole warrant, the parole case. And just to jump back to...
Just to step back for a second, as I see the record, the people didn't argue probable cause by itself. They argued it in combination, and in fact, that's how the appellate division ruled.
Well, I think that this was decided both at the trial level and in the appellate division under Huntley. This was considered to be a parole search, and I think that it is tempting in this case to kind of blur the lines and say, we got a little bit something, we got a little bit something else. What Huntley set forth was very clear. What they said is, and actually these were basically their words, the standard for evaluating the reasonableness of a search of a parolee by a police officer remains the familiar standard of probable cause, period. Not sort of diluted because he's a parolee, not, but we can kind of cut corners because he's a parolee. That's it.
So
Probable cause.
The warrant for his arrest, because he had absconded or was in violation of his parole, would not have been enough. That wouldn't have created probable cause here.
Absolutely not. And in Huntley itself, the defendant in Huntley was arrested on a parole warrant in Huntley. And despite that fact, this court in Huntley bent over backwards to say the relationship that this parolee has with his own parole officer is critical to this lesser standard. And in fact, in Huntley...
Would the parole officer have had to have been his parole officer? Could it not have been the parole officer who was assigned to this squad? You're saying none of those officers, parole officers assigned to the squad, could have arrested him on the warrant?
Well, what this court said, and I think there's a little bit of room, the only room I see for any kind of variation on the identity of the individual who can conduct or direct this search is, it has to be someone who has responsibility for supervising this parolee's parole. That said, you could have a situation where his own parole officer is on vacation, hands the case off to another field officer who has that dual responsibility that this court discussed in Huntley. And critically, it's tempting to say, look, what's the difference? A parole officer arrests him, a parole warrant officer arrests him. What's the difference? They search, he's got a gun, right? The difference is that the parole officer, the field officer who supervises him, has a dual purpose. And this court discussed...
Yeah, but when when he goes to arrest him, that purpose is not in play. That purpose is irrelevant. This is a law enforcement purpose that's being addressed, the arrest on the warrant.
For the arrest, Your Honor. But for the ensuing search, at least what this court said in Huntley.
But I think that's a somewhat, I'm having trouble with that application of Huntley, and I think this goes back to Judge Stein's point, because Huntley says what you quoted, which is it's a familiar requirement of a showing of probable cause, but then it says, right after that, even under that test, however, the fact of parole status may well be significant in individual cases. I think pretty clearly saying parole status is part of the probable cause analysis. They're labeling it, but it's a reasonableness analysis. It then goes on to say where, however, as here, the search and seizure is undertaken by even parolee's own officer. So Huntley sets out kind of a general rule and then goes on to apply it to those facts with the parolee and the parolee's officer and the purpose of the search. But the general rule is a reasonableness rule, looking at probable cause, but saying even in that probable cause analysis for a parolee, the fact that that person is a parolee may be significant in the probable cause analysis. And I think, to get back to what Judge Stein was saying, you have all these facts here: violation, the phone call, they know the person who's making the call, and it's a parolee, and it's being executed on a warrant where he's violated and has violated. Why doesn't that get you to the Huntley reasonableness test?
Your Honor has said a lot, and I'd like to respond to all of it. Very quickly on the facts.
Your light's on, sorry. No.
Very quickly on the facts, I'd refer to our reply brief as to whether or not they knew the woman who called. They didn't. He didn't know her name. But more important on what I think you've raised as the critical question in this case, which is probable cause versus Huntley, and where are we? And I think as long as we know which world we're in and what standard we're dealing with, defendant wins either way. If what I believe I just heard Your Honor say was essentially, look, it was a detective. I don't want to paraphrase, but I think what I just heard you say was it was a detective. Huntley, as in the reduced standard of a parole search, clearly doesn't apply to this case, Huntley, but I think I heard you say, but maybe probable
It's
cause
all the
does.
facts. So it's a detective, you want to categorize it, but it's a detective here who's working with the warrant squad, who's working with the parole officers on a violator of parole. So it's hard for me to apply a reasonableness test, which takes into account all these factors, and then see it as compartmentalized. So it's not his parole officer, and it's a detective. It's all one set of facts on a reasonableness analysis for parole, it seems.
It's one set of facts, but there are two very different standards. And I think the people approached this hearing from the very get-go as it's only about Huntley. They never said probable cause is diminished. They said at the beginning of the hearing he waived all his rights. This is only about parole. They never said the words probable cause. They never said the words automobile exception. In the entire hearing, the court issues its decision, it's all about Huntley. Anything the people would have you believe about probable cause in this case, in addition to the merits, it's double hearsay, we didn't know anything about the son. The police didn't even ask the son if he had sent the supposed hearsay text message. The probable cause argument is a ruse to distract from Huntley, but it was also waived and not preserved, which leaves us with Huntley, which is the preserved argument at the core of this case. And we're looking at Huntley, and flatly, the exception to the warrant requirement for a parolee's own parole officer, which was very clearly stated in Huntley and supported by a lot of discussion of the policy reasons, was simply not met in this case. And any alternative argument, I just add that this is something like the fourth alternative argument to Huntley that the people have thrown out in this case when you go back to
What about the agreement that he signs that he allows his property and himself to be searched at any time?
Thank you for mentioning the agreement.
I mean, your light is off, so quick or on rebuttal, one of the
Very quickly, may I respond now on the agreement? The agreement on its face tells us what Everett McMillan's actual expectation of privacy was. I'm not sure, and I don't believe that Huntley dealt with this actual agreement. The decision doesn't make that clear. But regardless of whether or not the court would ever do something and move away from Huntley, we know that this defendant, this parolee, had a reasonable expectation that the search provision, search item number 4, was what dictated his decreased, he does have a decreased expectation of privacy, and this tells you exactly what it was. And the search that was conducted violated that condition, and I may well have more to say about that document on reply.
Thank you, sir. Counsel?
Counsel, would you respond to the argument that we can't look at probable cause because that wasn't raised here?
Well, first of all, I believe it was raised. In fact, defense counsel raised it specifically at the hearing. He specifically mentions probable cause, and the people kind of counter that. It's really more of a credibility question at that point. So I think probable cause can be addressed here. But regardless, the touchstone of the Fourth Amendment is is the reasonableness of the search overall. And here the search was reasonable based on the severely diminished expectation of privacy of the defendant as a parolee and in his car, based on the high degree of individualized suspicion possessed by the police at the time.
So do you reach that threshold because of the phone call?
The phone
If there had been no phone call,
yes.
they just go to arrest. They have the keys. Can they search the car?
I believe they could do, if we're talking about under the Fourth Amendment, under Sampson
Well,
and Knight.
that was your argument. I'm
Yes.
staying with that argument.
Right, absolutely. They could search the car under
Based on
Sampson and
what?
Knights.
What gives them
The-
authority to search the car if what he was doing was going pursuant to this arrest warrant to arrest him?
Because they could perform a search that a parole officer could do. So just
So
as
why
in
is
Sampson,
that? Because a member of this team?
well, there's different facts that are going
No,
on.
no,
here.
why is that?
If I may, there's a Fourth Amendment analysis, and then there's what's going on in this case, which is even better than
No,
the
but you
cases under
said the reason they
Fourth
can,
Amendment.
unless I misunderstood you,
Yes.
please just clarify for me. They
Okay.
could search the car under the Fourth Amendment because he's acting like the parole officer, or he's a member of the team? What's the reason?
No, under the Fourth Amendment, he can do the search because it's objectively reasonable, because under all the facts and circumstances, the diminished expectation of privacy, and in this case, there's individualized suspicion, but not necessary. The Supreme Court says in Sampson.
So it's because he's a parolee? You search the
Yes, in
car
part
because he's a
because he's a
parolee?
parolee.
How does that get past Huntley?
Huntley is an interpretation of the Fourth Amendment. So to the extent that Huntley has now, we have new cases since then, it's a 40-year-old case, 2 cases from the Supreme Court, should be reevaluated in that light. But
You mean
secondly,
Sampson?
Sorry?
Sampson?
In Sampson, yes.
Yeah, but
Knights and
Sampson, don't they have a particular agreement? Hasn't he signed a particular agreement that includes peace officers?
There was a particular agreement in that case, except that the overarching analysis was reasonableness. And the court
I understand, but in Huntley, there was an agreement too, and the court said that agreement's not enough to diminish these expectations of the parolee to the extent that the search could be appropriate, right? You've still got to satisfy
Your Honor,
the
search was
threshold burden.
If I may, the search was upheld in Huntley.
No,
And-
I understand, but I'm saying the language in Huntley makes clear that merely signing the agreement doesn't mean that you can simply just go in and search at any time, right? It's not a
Absolutely true.
wholesale loss. I don't know if this agreement differs. I don't know if you know if the current agreement is different from the one in Huntley.
I don't know if this agreement was different from the one in Huntley. It may well be, because it has a different
been a long
provision.
time,
And it's got a specific provision in it that doesn't talk about parole officers, as I'm sure Your Honor is aware. But this decision in Sampson is clear. A completely suspicionless search was upheld in Sampson. And they make a distinction between the diminished expectation of privacy that comes about as a result of the defendant's status as a parolee alone, even without a consent agreement. At page 851 and 852 of the decision, it specifically says, as a result of his status alone as a parolee, he has a severely, they use the word severely, diminished expectation of privacy. Then they go on to talk about the consent agreement, and they decide, as a result of that, he has no expectation of privacy, no legitimate expectation of privacy.
But Huntley recognized the diminished expectation of privacy. I don't know that there's new law in Sampson from that. So where is the line? Because it almost sounds like you're saying, as long as the officer is going to check on a parolee or arrest a parolee, then the police officer, obviously not the parole officer, the law is very clear on that, can then search this car. It's not even his home where he's actually arrested. It's his car that's outside.
Right. And Sampson and Knights are one thing, but to affirm in this case, the court doesn't need to go nearly as far as those cases. All the court needs to do is to say that in a situation like this, where the police are executing a warrant on behalf of parole, and in the course of that learn new information, and in conjunction with parole, they learn new information after when that officer is not available that really constitutes probable cause or at least reasonable suspicion that they're allowed to act on that and to
So
take
then the
into
case
account.
turns on that phone call. They didn't have
Much
the
of this-
phone
much of
call,
it
you
turns
might
on-
agree it's at least a close case.
I'm sorry, Your Honor.
Without the phone call, it sounds
Without
like
the
you might
phone
agree
call, I
it's a
don't think it's
close
a-
case.
I don't think it's a close case under the Fourth Amendment, but you could say under Huntley it is closer. Here's the big distinction with Huntley, if I can just say that. Huntley is not a case that deals with new information acquired during the course of the execution of the warrant. Huntley deals only with parole officers. There's no police officers who are involved in Huntley in any way. And the court...
Let me ask this.
Yes.
Do we have to take a step back to Sampson a second?
Yeah,
Do we have to adopt the reasoning in Sampson to uphold this search?
absolutely not.
Why not?
Because here, you have the unique circumstances where this is in the process of the execution of a warrant. The police are acting not only at the behest of parole, but with parole. There's a specific parole warrant officer assigned to this case, and the only reason he's not there at the time that all of this goes down is because he happens to be off duty when they get the call that specifically says the defendant is returning to the premises and he's got a gun in his car. That's why they act then. And even then, they're still in contact with the parole officer at the time, both before and after the arrest. So the case really comes down to this. First of all, could a parole officer have conducted this search?
What was
And I
the
don't think there's-
detective's reason for searching the car?
I'm sorry, Your Honor.
What did the detective give as his reason for searching the car?
He spoke about the landlord asking
Well, that's
him...
about
to get-
moving the car, the search of the car for the gun.
Well, the search of the car, he leaned inside. He did look. He was looking for the gun at that point in order to secure it before he moved the car. But in any event, the subjective motivation of the officer is not relevant. It's not relevant under Knights and Sampson. Knights specifically says the subjective motivation of the officer is not
Well, no,
relevant.
my question is about what role he was serving at that point. Have his hat on as stepping into the shoes of the parole officer or as a police officer?
But that's really an inquiry into the subjective motivation of the officer, and that
So is
is
that the basis for the
unnecessary.
authority? Aren't we sort of tracking back to the basis for the authority?
I'm sorry, Your Honor. Could you say that again?
Aren't we tracking back to the basis of the authority?
Well, there's really two lines of authority here, to be clear. There's one under the Fourth Amendment where police officers are allowed to do an objectively reasonable search if all the facts and circumstances justify it, and they do here. The second line of authority, which really applies in this case and makes it even better than the ordinary case, better than Sampson and Knights, the second line of authority is through the parole officers, because they're acting on behalf of the parole officers when they conduct this search.
You
And it may-
disagree then with your adversary that it had to be his parole officer, not just one of the officers who's assigned to the warrant squad?
Absolutely not. And just from a policy or practicality point of view of holding to that effect, if the defendant absconds from Queens and he's found in Buffalo, what that would mean is that in order to do a search attended to the execution of the warrant at that time of his premises or of his car that was outside, they'd have to fly his own parole officer up from Queens to Buffalo just to do that search.
Let me ask you this. Let's assume for one moment that we disagree that a police officer under these circumstances would have had the authority to search the car. Let's just for one moment go with that. Assume your position then is because he's stepping into the shoes of the parole officer, he's working on this particular team, that he could then, clothed with the authority of the parole officer, search the car. Is that
Yes.
correct? Okay. So just on that second track, is that then an end run
I don't
around our
believe so.
holdings regarding the authority parole officer has versus the authority a police officer might have?
No, Your Honor, because the search is justified here in either event.
Okay.
The interests of parole and the interests of the police coincide at this point. They merge, because at this point, the defendants violated the no firearm provision of the specific provision of the certificate of release. And that is a parole violation, and obviously, it's also a new crime. So the interests are really merged here. And it would have been derelict on the part of any probation or any parole officer not to do the search in this case, knowing specifically that there was a violation of the no firearm provision and not to actually do the search in this case really would have been remiss in their duties. The question is there some benefit to the defendant, to society at large, from preventing a police officer from doing the search under the circumstances
Here's
of
the
this
problem,
case?
though, from a policy point of view. And I'm not sure, there may be areas of law that I haven't seen. I can't imagine this factual scenario hasn't happened, but let's presume that you're arresting someone on a parole warrant for a violation, and that means you're a police officer going to execute it. And let's say you can go ahead and do that. While you're executing it, you see someone else in the same place committing a crime, manufacture of drugs or whatever, when you're executing the parole warrant. You would have never been able to see them. You would have never been able to get a warrant to go into that house to search that, but for the parole violation that's being executed. So on the basis of the lowered standard, you're able to conduct a search and arrest non-parolees for a crime that they committed, because this is the danger in your argument, and this is the danger of what I see, because for you to have gotten a warrant before, it would have had to have been reviewed by a judge before you could have gone forward. But here, that wouldn't have had to take place. So it would give you access and searches that you simply wouldn't be eligible to get. Go ahead.
If I may, under the executive law, any police officer can
execute a warrant. But to get the warrant in the first place, there still has to be a judicial review for those non-parolees. The parolee gives up that right. The parolees waive that right already. You see the problem?
If I may, I'm not sure that I do.
No, that's all right.
I think in that particular circumstance that you'd have a plain view exception to the warrant requirement, because you'd have the police officer on the location.
But you wouldn't be there, but you would not be present in a place where the crime was taking place, but for the execution of the parole warrant.
But that's a completely lawful operation on the part, under the executive law and under the terms of the warrant itself.
Would a parole officer be able to make an arrest of a third person under those circumstances?
I believe so, yes, because they are lawfully on the premises, they observe in plain view contraband, and the individuals who are responsible for that contraband could be arrested, absolutely.
Thank you,
Your
counsel.
Honor.
Mr. Dunn?
Your Honor, I just have to correct a quick fact first. The detective, the New York City police detective who conducted the search in this case, had never spoken to appellant's own parole officer, ever. He had contact.
Assuming that it doesn't have to be that very parole officer, then the question becomes, could it be somebody specifically designated to step in for that parole officer while he or she is on vacation, or could it be somebody in this special unit whose job it was to issue or execute on parole warrants? But
yes, and
let's assume that it doesn't have to be the very parole officer.
Yes, well, my adversary just said that he had been in contact with appellant's parole officer, and he had been in contact only with the warrant officer, very different relationship, as this court explained in Huntley, dual purpose. The parole guidelines explain that a parole officer, a field parole officer, has two jobs, peace officer and caseworker. The detective who arrested appellant in this case and conducted the search was not a caseworker.
Well, where do we draw that line? So if he was on the phone with the parole officer, but the parole officer wasn't physically present, that would be okay?
I think there are closer cases down the road. This isn't one, but if there's some communication with the actual parole officer.
When? 5 minutes, an hour, that day?
That may be a case that this court gets someday, but when it's just a New York City police officer who's never even spoken once with the actual parole officer, it clearly fails.
But he knows why he's there, right? He's got the parole warrant, it's for these violations, they've been trying to find him earlier in the day, he knows why he's there, and then the call comes in, and now they're also made aware of at least some allegation that the parolee has a gun or had a gun at one point in the car earlier that day.
Yes, and to answer the question Your Honor posed my adversary, what Detective Hurley said when he was asked, why did you look in the car? He said, I was looking for the gun in the gun call. At that point, defendant had already been arrested. He was already in a police car, and there was no reason not to get a warrant. I think we can lose.
I'm sorry, did defense counsel, as the people say, argue probable cause?
Defense counsel never argued probable cause. He did say the words probable cause in the course of making a convoluted argument, essentially, that the parole exception was not met here. I would refer the court to the 2 pages right before the hearing begins and the argument at the end. Any argument, any argument other than the Huntley parole search in this case is waived, completely unpreserved, and frankly, a
Okay,
distraction.
I think you did mention that, but on that point about the practicality of waiting for the parole officer who is actually dealing with this particular parolee, doesn't it make sense that you wouldn't want to have to wait for that one particular person?
To be clear, we're not saying that he couldn't have been arrested on a parole warrant. He could have been arrested, but no, I don't think that there's
They
anything.
couldn't search his car because it's not his parole officer?
I don't think there's
His
any.
personal parole officer?
I don't think that there's any reason why they wouldn't need a warrant if they've already arrested him on the parole warrant. The gun is or is not inside a car. At that point, there's no exigency, there's no urgency, there's no danger. The Huntley exception doesn't apply since it's a police.
If we disagree with you about the question of this argument over probable cause, do you lose?
No. You
Why
mean
not?
on the preservation
If
aspect?
you could take it, take your argument is you can't take the phone call into consideration, they should have gotten this warrant. Even a police officer coming into this situation doesn't have probable cause. Right, Judge Garcia was asking you about this before.
Right.
So if we disagreed with you on that,
Right. If let's see, I get kind of my head spinning with it. I mean, if we assume that an argument that the police had probable cause in this case was preserved, and could the court, on the merits, I think it's a double hearsay problem, refer the court to the record, but Detective Hurley, he didn't know the name of the woman who made the call. It was double hearsay because she was reporting something that she was allegedly receiving from her son, whose name she never provided to Detective Hurley. He didn't give that information at the hearing. Even upon arriving at the house where appellant was to be found and meeting the person who actually was.
you're arguing that there is no probable cause. Let's assume we disagree with you. Do you then lose?
I mean, if the
If an
people.
officer in the situation has probable cause to search, what?
I'm sorry, if the people preserved a probable cause argument, and if they in fact had probable cause,
Yes.
then I guess we would lose, but neither of those things are true.
Thank you, counsel.